All right, good morning, everyone. This meeting is called to order. Mr. Trotman, has anyone signed up for public comment? Thank you very much. Good morning, Ms. Miller.
Good morning, sir.
Okay, on agenda item 3, there's a few cases that we need to reconsider.
That is correct.
Thank you.
Commission Appeals is requesting letters of continuing jurisdiction. And in all of these cases, the decisions were mailed more than 14 days ago, and there's no indication of further appeal, but the decisions are void on their faces. 5 decisions are void because they omit descriptive language in the signature section and don't accurately reflect the full vote of the commission. These are case numbers 3010841 from docket 32 this year. Case number 3071136 from docket 13 this year. Case number 3113878 from docket 34 this year. Case number 3133956, docket 27 this year. Case number 3378097, docket 39 this year. We're going to request letters of continuing jurisdiction so these cases can have corrected decisions mailed out. Then there are 4 decisions that are void because they reflect multiple dissents instead of a majority vote. These are case number 2837112 from docket 23 this year. Case number 3089278 from docket 35, 2022. Case number 3105221, docket 33, 2022. And case number 3214937 from docket 4 of this year. We're requesting letters of continuing jurisdiction in these cases so they can be resubmitted on a future docket. Commissioner Demerson.
I agree.
Thank you. Commissioner Trevino.
I agree.
Thank you. And Mr. Chairman.
Agreed.
Thank you very much, gentlemen.
All right, now on agenda item 4, tax liability cases. I think we have 1 tax case on docket 43 and 1 tax case on docket 44.
Yes, that's correct. Good morning, Hugh Daniel, Special Program Appeals. The case we have on docket 43 is styled TD-23-018-0623. Commissioner Demerson.
I agree with staff recommendation.
Commissioner Trevino.
I agree with staff's recommendation.
Chairman Daniel.
Rehear to determine where the work was performed and any financial investment of the speech pathologist.
Do we have any changes to any other votes?
I agree with the chairman. We're here.
And the case for docket 44, are you ready?
Ready?
Yep.
The style of the case is TD-23-020-0823. Commissioner Demerson.
I agree with staff recommendation.
Commissioner Trevino.
I agree with staff's recommendation.
And Chairman Daniel.
Agree with staff recommendation.
And that's it for me.
All right, no fair housing cases, no child labor cases. Under agenda item 7, we have no wage claim cases on dockets 43 or 44 pulled for additional discussion. I move we accept staff recommendations on the remaining wage claim cases on dockets 43 and 44.
Now, second the chairman's motion, except for the cases on which I'm dissenting is reflected in the wage claim short form dissent list for docket 43 and 44.
I concur with chairman's motion, except for those cases on which I am dissenting, as reflected on wage claim short form dissent list for docket 43 and 44.
Motion passes with the exceptions noted. Let's move to agenda item 8, consideration of unemployment insurance cases on docket 43. Please proceed when you're ready.
Case number 2676904, Commissioner Demerson.
We should reverse the appeal tribunal decision. Although the AT1 decision was mailed at the end of 2020, the employer's Rule 16 hearing was not scheduled until more than 2 years after the first hearing. Since the extended delay in scheduling the hearing led to possible loss of information and available witnesses that were privy to the employer's good cause issues, we should not penalize the employer for its lack of information at the hearing. As such, we should hold that the employer established good cause for missing the AT1 hearing and resubmit the case for the merits testimony.
The AT decision should be affirmed. The employer did not establish good cause for their non-appearance at the AT1 hearing because the employer representative who participated in the hearing had no information regarding whether the employer did not appear. Regarding the separation, there are no facts on the record that show that the claimant was separated under disqualifying circumstances. Affirmed the AT, employer did not establish good cause for its non-appearance at AT1. Bill the reimbursing employer.
Employer established good cause for AT1, resubmit.
We will resubmit the case.
Case number 2970523, Commissioner Trevino.
The AT3 decision should be modified. I agree that the claimant established good cause for his failure to appear at the AT2 hearing. However, commission records established that the claimant filed a timely petition to reopen AT1. Additionally, regarding the claimant's failure to appear at AT1, the claimant was initially qualified to receive benefits and receive benefits until he stopped filing payments requests on September 22nd of 2021. The claimant was unaware that the employer had filed an appeal to the initial determination and had no reason to know that he needed to update his address with the commission when he moved. The hearing was not held until almost 9 months after the initial determination, since the claimant did not receive the hearing notice for the AT1 hearing due to the delay in scheduling a hearing in his case. The claimant had good cause for his failure to appear at AT1. Modify the AT. Claimant had good cause for AT2. Timely petition to reopen. Claimant had good cause for AT1. Resubmit.
We should modify the appeal tribunal decision. First, I do not contest the AT2 good cause issue or the timeliness of the claimant's Rule 16 petition to reopen. Concerning AT1, the claimant did not update his address with the commission, which led him to not receiving the AT1 hearing notice. Since the claimant was not prevented from appearing at the AT hearing due to circumstances beyond his control, the claimant did not establish good cause. Concerning the timeliness of the employer's protest, the employer materially relied on the deadline shown on the side system regarding the date to file a timely response. Since the employer's late response arose from misinformation from the side's platform, the employer's protest should be held timely. Concerning the job separation, the claimant was terminated when he violated the employer's safety rule by driving a non-street legal vehicle onto the freeway. Since the claimant's unsafe actions jeopardized the safety of himself and other members of the public, the claimant mismanaged his position of employment. As such, we should modify the AT decision. The claimant established good cause for missing the AT2 hearing. The claimant filed a timely Rule 16 petition to reopen. The claimant did not establish good cause for missing the AT1 hearing. Timely employer protests, misconduct, no chargeback, sever adequate employer response.
Timely petition to reopen, claimant established good cause for AT2 and AT1, resubmit.
We will resubmit the case.
Case number 3075726, Commissioner Dimerson.
The AT decision should be modified. I agree that the employer's response to the notice of maximum potential chargeback should be considered timely. Concerning the chargeback issue, the employer's witness presented undisputed testimony that the claimant was fired for harassment against a female employee after having received a final warning a few months earlier. The fact that no firsthand witness testified about specific details on the final incident should not be held against the employer, since the claimant was fired in May 2019, and the employer was not to blame that it did not get a hearing until almost 4 years later, and almost a year and a half after it appealed the initial determination. The available evidence is sufficient to find that the employer is entitled to a chargeback protection. Accordingly, we should modify the AT decision. The employer filed a timely protest and protect the employer's account from chargeback.
The decision is correct, since the employer's response to the notice of maximum potential chargeback was delayed due to the shutdown caused by the onset of COVID-19 pandemic. I do not contest the timeliness of the employer's response. Regarding the chargeback issue, the employer failed to provide sufficient specific details as to the claimant's action that led to the discharge to determine that the claimant was discharged for a disqualifying reason. As such, the employer's account should be subject to charge. Affirm the AT, timely response to the notice of maximum potential chargeback. Charge the employer's account.
Timely response to the NMPC, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3180226, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant was discharged due to poor performance. As the only party that attended the hearing, the hearing, the employer testified that the claimant's issue dealt with paying attention to detail, such as entering VIN numbers correctly. In addition, the employer also testified that the claimant seemed like she was not trying and that she also did not want to talk about issues with customer interactions. Entering numbers correctly does not immediately indicate a complex task. Putting forth a trying effort is within one's power to control, and not wanting to talk about issues with customers' interaction signals a reluctance to improve performance. In sum, the employer has established that the claimant was not working to the best of her ability and was therefore discharged for work-connected misconduct. As such, we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision should be modified. The claimant was discharged due to her failure to meet the employer's performance expectations. There is no evidence that the claimant was ever able to meet the employer's expectations. The claimant's statement to the commission indicate that she was working to the best of her ability and coming in early to get ahead. The claimant's inability to perform the job to the employer's expectations does not constitute misconduct connected with the work. Modify the AT, no misconduct, impose chargeback.
Misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3351745, Commissioner Trevino.
The AT decision should be modified. The claimant established good cause for missing AT1 hearing because of delayed receipt of the hearing notice, which had been misdelivered to his neighbor. The claimant registered for work in the state of California on August 19th of 2022. The registration and eligibility should be closed when he registered for work as instructed by the commission. Modify the AT, claimant established good cause for missing AT1, registration not eligible, 7/31 of 22 through 8/20 of 22.
We should affirm the appeal tribunal decision. First, I do not contest that the claimant established good cause for missing the AT1 hearing. Concerning the registration issue, the claimant did not inform the commission about his registration status until September 23rd, 2022. As such, the claimant's ineligibility should close the week ending September 24th, 2022. Affirm the AT decision, registration not eligible from July 31st, 2022 through September 24th, 2022.
Claimant established good cause for AT1, registration not eligible July 31st, 2022 to August 20th, 2022.
So the closure dates
Agreed.
differ, Commissioner Dimerson.
We're going to stay with September 24th, 2022.
Yes, the closure date's the only difference. Are you going to dissent?
Yeah, short form dissent.
Yes, sir.
Okay.
Thank you.
Thank you.
Case number 3387553, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The employer witness who provided testimony on the good cause issue stated that she was out of the country during the date and time of the scheduled hearing. As such, the employer had good cause for its non-appearance. We should therefore reverse the AT decision. The employer had good cause for its non-appearance, resubmit. In the alternative, even if the employer did not have good cause for its non-appearance, we should modify the AT decision. Between the claimant's testimony and the party's fact-finding statements, a reasonable conclusion can be reached that the claimant requested a reduction in her hours. A reduction of hours that is initiated by the claimant means that any subsequent periods of unemployment are the claimant's to bear. As such, the claimant's request to reduce her hours resulted in job separation that was voluntary and without work-connected good cause. Should therefore modify the AT decision. The employer did not have good cause for its non-appearance, voluntary leaving, no chargeback, adequate employer response.
The AT decision is correct. Regarding the good cause issue, the employer's representative was out of the country at the time of the hearing, but testified she could have participated in the hearing if she had been aware of it. The employer admitted that the hearing notice may have been received prior to the employer's trip, but the employer failed to properly monitor their mail. The employer therefore failed to establish that it was prevented from participating in the hearing by circumstances beyond its control. Regarding the job separation, The claimant requested a temporary reduction in her hours to only work on the days when the facility was busier, while the employer installed safety precautions. The claimant had good cause connected with the work for this request because it was precipitated by an incident in which the claimant's life was put in danger due to part of the lack of these necessary safety precautions. Affirmed the AT, employer failed to establish good cause for missing AT1 hearing. No voluntary leaving, chargeback.
Employer established good cause for AT1, resubmit.
We will resubmit the case.
Case number 3397487, Commissioner Trevino.
The AT decision is not supportable. At the beginning of the pandemic, the claimant worked for two employers. While he continued to work for the named employer, he was laid off from his other employment due to the pandemic. After the layoff, the claimant filed for unemployment benefits for the first time. The claimant made a reasonable mistake and did not understand that he needed to report wages from this employer on his payment request. Many other claimants make the same mistake and are simply issued an earnings adjustment overpayment. There is no evidence that distinguishes the claimant's failure to report his earnings as anything other than a simple misunderstanding. The claimant's action did not rise to the level of willful non-disclosure or misrepresentation, as is required for a fraud finding. Modify the AT, no fraud, recompute overpayment.
The AT decision is supportable. The evidence establishes that the claimant worked substantial hours and had substantial earnings while filing his weekly claims, yet failed to report any of the work and earnings on the claim forms. There is no ambiguous messaging from TWC regarding the requirements for filing claim certifications. Instructions to report work and earnings on each weekly unemployment claim could not be any clearer. Claimant had no reasonable basis for believing that he did not need to follow those standard requirements. Accordingly, we should affirm the AT decision. The claimant committed fraud in connection with his unemployment claim, overpayment of $13,546.
Forfeiture provisions applied, overpayment.
Short form dissent, ma'am.
Yes, sir.
Case number 3445888, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant was discharged for an interaction he had with the campus police officer. Indeed, the employer witness stated that the final incident conduct involved the encounter the claimant had with the officer. The weight of the credible evidence establishes that the claimant approached the officer during a traffic stop and asked her to remove her vehicle because it was blocking his handicapped parking space. Per the officer's statement and filed documents, the claimant was instructed to go around, but instead approached the officer, which resulted in the officer having to completely divert her attention away from the traffic stop to handle the complaint. Interrupting an officer in the middle of a traffic stop could have resulted in serious safety implications for the officer and others. Moreover, the claimant failed to treat the officer with respect or dignity per the report from the employer's due process committee. As such, the claimant's actions constituted work-connected misconduct. We should therefore reverse the AT decision, misconduct, reimbursing employer not billed, adequate employer response. In the alternative, I could also support a vote to rehear this case to obtain a copy of the video recording of the incident as well to enter the witness statements provided by the employer in its appeal to the commission into record, and also to take testimony from the officer in question who was approached by the claimant.
The AT decision should be affirmed. The claimant, a tenured college professor and disabled veteran, was discharged by the employer following his arrest for an incident in which he requested that a campus police officer remove her vehicle, which was blocking his access to handicapped parking spaces. The claimant offered the only firsthand testimony regarding the incident that led to his arrest and denied allegations of misconduct. Additionally, the charges against the claimant were dismissed not only once, but twice. The employer has failed to establish that the claimant's action constituted misconduct connected with the work. Affirm the AT, no misconduct, bill reimbursing employer.
No misconduct, bill reimbursing employer.
Short form dissent.
Yes, sir, Commissioner.
Thank you.
Case number 3472440, Commissioner Trevino.
The AT decision is not supportable. The employer explicitly testified that the claimant was discharged for discussing his pay with a coworker, who was also the claimant's roommate. The claimant and his roommate discussing their pay after hours and deciding how to allocate funds to pay their personal obligations such as rent and grocery bills. There is no evidence that the claimant's actions in discussing the pay with his coworker were disruptive to the workplace. The claimant provided credible and persuasive testimony in which he denied asking to work a 4-day work week or requesting to be discharged. The employer's decision to fire the claimant because of his concerted activity violated the NLRA. As the claimant was engaging in protective activities, his actions were not misconduct and should be qualified for benefits. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The claimant became dissatisfied with his schedule. Per the employer's response to the claim notice, when asked what he would do if scheduling demands were not met, the claimant replied that he hoped the owner would fire him so he could file for unemployment. The employer's response also revealed that the claimant's attitude had turned bad and his work ethic declined in the week before his termination. Accordingly, the claimant's actions constituted work-connected misconduct. We should therefore affirm the AT decision, misconduct, no chargeback.
No misconduct, chargeback.
I'm sorry, did you say no
No
misconduct?
misconduct, chargeback.
Thank you.
Short form dissent.
Yes, sir.
Case number 3492631, Commissioner Trevino.
The AT decision is not fully supportable. The claimant filed a valid claim. The claimant contacted the employer on the day she was laid off by the client company because she did not know what to do. The employer's representative did not inform her that she needed to report her availability for other assignment. As such, the claimant's contact with the representative on the day her assignment ended satisfied the employer's policy that she make herself available for work within 3 days of her assignment ending. Additionally, the employer did not have any other assignment for the claimant until 10 days after her last assignment ended. Clearly, the claimant was laid off from the employer due to lack of work. Modify the AT, valid claim, no misconduct.
We should affirm the appeal tribunal decision. First, I agree the claim is valid. Regarding the job separation, because the claimant did not comply with the employer's reporting policy, the claimant is considered to have quit without good cause connected with the work. Affirm the AT decision, valid claim, voluntary leaving.
Valid claim, voluntary leaving.
Short form dissent, ma'am.
Yes, sir.
Case number 3501241, Commissioner Demerson.
We should grant a rehearing in this case. The claimant was discharged for serious violations of the employee discount policy. While the claimant denies wrongdoing, her testimony lacks credibility. 16 pages of additional documents from the investigation conducted by the Loss Prevention Department bring to light several inconsistencies and contradictions in the claimant's statements to TWC. These documents are clearly relevant and should be admitted for our review. In addition to these documents, we should also consider testimony from the employer's firsthand witnesses. Accordingly, we should grant a rehearing for admission of the employer's documents and for testimony from the employer's firsthand witnesses.
The AT decision is correct. The employer terminated the claimant for allegedly violating the employer's discount policy. The claimant denied the allegation of misconduct, and the employer failed to provide any direct evidence or firsthand testimony. Therefore, the employer has failed to meet its burden of proving that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Rehear.
We will rehear the case.
Case number 3506174, Commissioner Demerson.
We should reverse the appeal tribunal decision. Although the claimant was repeatedly warned and received adequate training regarding the use of personal devices at the workplace, the claimant continued to violate the employer's rules. Since the claimant was warned about her workplace conduct, which negatively affected her work product, the claimant mismanaged her position of employment. As such, we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision is correct. The claimant was discharged due to her failure to meet the employer's performance expectations. The claimant was never given any formal warnings about her job performance, and the employer failed to present any evidence that the claimant was put on notice that she would be terminated from her position if her performance did not improve. Therefore, the employer has failed to meet its burden of proving that the claimant was discharged for misconduct connected with the work. Regarding the chargeback issue, though the employer argued that the claimant was an independent contractor, the evidence established that the claimant was paid by the hour and worked under the employer's direction and control. The claimant was an employee and the chargeback ruling was appropriate. Affirm the AT, no misconduct, chargeback.
No misconduct, chargeback.
Short form dissent.
Yes, sir.
Thank you.
Case number 3512749, Commissioner Trevino.
The AT decision should be modified. I agree that the commission records establish that the claimant filed a timely appeal. However, regarding the job separation, the claimant was on the phone with the customer and thought that she had muted her line and used some very mild profanity towards her dog, who was misbehaving in the background. The customer could not reasonably believe that the complainant's comment was aimed towards her. Though the claimant should have used better judgment, the claimant had received no prior warnings, and the employer has failed to establish that this single incident was sufficient to establish work-connected misconduct. Modify the AT, timely claimant appeal, no misconduct, chargeback.
We should affirm the appeal tribunal decision. First, I agree that the claimant filed a timely appeal. Regarding the job separation, the facts are not in dispute. A customer heard the claimant use profanity during a call and filed a complaint. This was a violation of the employer's policy. Thus, the claimant mismanaged her position of employment. Affirm the AT decision, timely claimant appeal, misconduct, no chargeback.
Timely claimant appeal, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 3526286, Commissioner Trevino.
The AT decision is not supportable. The claimant had a family emergency regarding his minor stepdaughter, who was taken to the hospital after being involved in a car accident. The claimant received the news in the middle of his overnight shift. The claimant attempted to locate and notify a manager of his need to leave for 30 minutes. After being unable to contact a manager, the claimant informed his coworkers that he had to leave due to a family emergency and left. The claimant's separation was urgent, compelling, and necessary, and therefore not disqualifying under Section 207.046 of the Act. The employer's account should also be protected from chargeback. Modify the AT, no misconduct, no chargeback, urgent, compelling, and necessary.
We should modify the appeal tribunal decision. The claimant left work early without authorization and without clocking out. He stated that he could not find a supervisor before leaving work, yet the claimant failed to notify the employer of his absence for several days. Because the claimant mismanaged his position of employment, we should modify the AT decision, misconduct, no chargeback.
Misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3528937, Commissioner Dimerson.
We should modify the appeal tribunal decision. First, I do not contest the validity of claim issue. Concerning the job separation, although the claimant was repeatedly warned about the use of cell phones at the workplace, the claimant was terminated when she used FaceTime to communicate with a former colleague during work hours. While the claimant alleged that she contacted the former colleague regarding a work-related matter, the record shows that the claimant did not have authorization to contact the colleague. Since the claimant was aware and warned of the employer's rule against the use of cell phones during work time, the claimant's unauthorized use of her cell phone was mismanagement of her position of employment. As such, we should modify the AT decision, valid claim, misconduct, no chargeback, and adequate employer response.
The AT decision should be affirmed. The employer failed to provide that the claimant violated any company policy. The claimant testified that she was authorized by the owner of the business to call a specific former employee to ask work-related questions when necessary. The claimant's testimony that she regularly called this employee to ask questions was supported by the testimony of the former employee, who testified that the office manager had also reached out to her in the past. Since the claimant was acting with the employer's permission, she cannot be considered to have violated policy. Affirm the AT, valid claim, no misconduct, chargeback.
Valid claim, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir. Thank you. And that was the last unemployment insurance case pulled for additional discussion on docket 43. You should have received the UI short form dissent list for docket 43.
I move we accept staff recommendations on the remaining UI cases on docket 43, except for the case in which I'm dissenting as reflected on the UI short form dissent list for docket 43.
And I second the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 43.
And I concur with chairman's motion, except for those cases in which I am dissenting as reflected on UI short form dissent list for docket 43.
Motion passes with the exceptions noted.
Thank you. Proceeding to docket 44.
Case number 2629851, Commissioner Dimerson.
We should reverse the appeal tribunal decision concerning good cause for missing the AT4 hearing. The employer provided credible testimony that he was out of the country when the notice of hearing was sent and on the date of the hearing. Since the employer was unable to attend AT4 due to circumstances beyond his control, the employer established good cause for his non-appearance. Concerning the AT3 and AT2 hearings, the employer's petition to reopen in conjunction with the employer's sworn testimony specified that he was unable to attend the hearings due to non-receipt of the hearing notice. Concerning AT1, the employer was unable to attend the hearing due to a medical emergency involving a family member. Since the employer was unable to attend the hearings due to circumstances beyond his control, we should find that the employer established good cause for missing the AT4, AT3, AT2, and AT1 hearings and resubmit the case for merits testimony.
The AT decision is supportable. The employer failed to establish good cause for failing to appear for the AT4 hearing, and the employer did not provide persuasive evidence that they were prevented from participating in the hearing due to circumstances beyond their control. The ruling to the work separation is supportable. The claimant provided credible firsthand testimony that he was hired for a major project. Once the project was completed, he was laid off and no further work was available for him to perform. Therefore, the claimant's separation from the employer was not due to misconduct connected with the work. Affirm the AT, employer failed to establish good cause for missing AT4, AT3, AT2, and AT1 hearings. No misconduct, avoid chargeback.
Employer established good cause for AT1, AT2, AT3, and AT4. Resubmit.
We will resubmit the case.
Case number 2971965, Commissioner Trevino.
The AT decision should be affirmed. The claimant worked for a home health care agency, and she was notified by the employer that her assignment had ended. Though the claimant was not separated from her employment by her assignment ending, the claimant was not offered another assignment for 2 weeks prior to filing her claim for benefits. The employer's failure to offer the claimant additional work after her assignment ended severed the employment relationship. Therefore, the claimant was laid off due to lack of work when she was not offered additional work following the end of her assignment. Though the employer has attempted to position themselves as a temporary help firm by enacting a policy requiring employees to report back to the employer for additional work at the end of an assignment, the employer is not a temporary help firm covered by section 207.045H. Affirm the AT, no misconduct, chargeback.
We should reverse the appeal tribunal decision. After the claimant's assignment ended, she did not contact the employer to request further work as required by policy. Under the home health president, by failing to request another assignment and subsequently filing an unemployment claim, the claimant clearly notified the employer that the employment relationship had ended. In the absence of testimony from the claimant, the preponderance of the evidence established that the claimant quit without good cause connected with the work. should reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
No misconduct, chargeback.
Short form dissent.
Yes, sir.
Thank you.
Case number 3112165, Commissioner Trevino.
The AT decision should be modified. I agree that the claimant had good cause for missing the hearing due to time zone confusion and that he filed a valid claim. Regarding the separation, the claimant was only employed for 4 months and never met the employer's performance standard as a warehouse manager. The job duties of such a managerial position are complex. The claimant's inability to meet the employer's performance expectations due to his short tenure with the employer is not misconduct. Modify the AT, valid claim, claimant established good cause for missing AT1 hearing, no misconduct, chargeback, void adequate response.
We should modify the appeal tribunal decision. First, they did not contest that the claim was valid or that the claimant established a good cause for missing the AT1 hearing. Concerning the job separation, although the claimant worked for the employer in a managerial role with heightened job responsibilities, the claimant was terminated when he did not complete a customer purchase transfer within the acceptable time frame. Since the claimant acknowledged that it was his responsibility to supervise and ensure that client purchases were transferred, his failure to do so was mismanagement of his position of employment. As such, we should modify the AT decision, valid claim. The claimant established good cause for missing the AT1 hearing, a misconduct, no chargeback, sever adequate employer response.
Claimant established good cause for AT1, valid claim, no misconduct, chargeback, void adequate response.
Short form dissent.
Yes, sir.
Thank you.
Case number 3224246, Commissioner Dimerson.
We should reverse the appeal tribunal decision. Good cause finding. Prior to the AT hearing, the employer submitted a request to reschedule because the employer's primary witness was not available due to a conflict with the surgical procedure. When the employer's representative called in on the day of the hearing, it was to check on the status of the postponement request, not to participate in the hearing without its primary witness. Because the employer notified TWC of the conflict in advance and the employer's primary witness was not available to testify, the employer had good cause for its non-appearance and the case should be resubmitted for merits testimony.
The AT decision is correct. The employer failed to establish good cause for missing AT1 hearing. The employer's witness provided inconsistent testimony as to the reason for missing AT1 hearing. Furthermore, although the employer's witness presented testimony that they intended to participate in the hearing, that individual mistakenly believed that the hearing officer was going to call her for the hearing. Misreading the notice does not constitute good cause for failure to appear. As for the separation issue, the claimant provided consistent statements that the separation was due to a minor infraction and did not rise to the level of misconduct. Affirm the AT, employer failed to establish good cause for missing AT1 hearing, no misconduct.
Employer did not establish good cause for AT1, misconduct.
Commissioner Trevino, could you tell me again your vote on the good cause issue?
Yes, ma'am. It was affirm the AT. Employer failed to establish good cause for missing AT1 hearing, no misconduct.
And Mr. Chairman, you said no good cause as well,
Correct.
but then there's no majority vote on the separation issue.
Sherry, I'm going to go ahead and agree with the chairman.
Okay.
Okay.
That would make the majority vote no good cause, claimant disqualified.
Okay. Short form dissent, ma'am.
Yes, sir.
Thank you.
Case number 3328853, Commissioner Trevino.
The claimant's motion for rehearing should be granted. The claimant was presented new evidence that she was wrongfully terminated, and after the investigation by the employer, was reinstated to her position of employment. Commission records show that the employer began reporting wages for the claimant again after her separation in June of 2022. If the claimant was wrongfully terminated, she should be qualified for benefits during the benefit weeks that she was unemployed before the employer reinstated her employment. At the rehearing, the testimony should be taken from the claimant and the employer regarding the post-termination investigation and reemployment of the claimant. Grant the claimant's motion for rehearing.
The claimant's motion for rehearing should be denied. The claimant did not meet the required criteria for the commission to grant her motion. As such, it should be denied. Deny the claimant's motion for rehearing.
Grant the motion for rehearing.
The rehearing, motion for rehearing is granted. We will rehear the case.
Case number 3390050, Commissioner Trevino.
This case should be reheard because the record was not well developed. The record is unclear as to whether the payments were made because the claimant's working as a result of a collective bargaining agreement or the result of an employer supplemental unemployment insurance program. Further, the record is unclear as to whether the earnings adjustments in this case are regarding the same payments that were considered as non-disqualifying remuneration in the previous determination dated October 30th of 2020. This case should be reheard to adequately develop the record as to any hours the claimant worked during these benefit weeks and the nature of the payments made. Rehear.
The AT decision is partially supportable. The evidence establishes that the claimant did not report her earnings correctly according to commission rules. The earnings adjustments were based on the data reported by the employer and were appropriate. The earnings adjustment created an overpayment of benefits, which the decision correctly recognizes. Concerning a waiver of the overpayment, the claimant had a complicated situation involving an employer's program to pay employees a portion of their usual wages as part of an agreement not to lay them off. The program requirements during the pandemic were complex and led to many questions. Reaching TWC for clear answers on claimant-related questions was difficult during the pandemic, and the claimant gave credible testimony that the advice she received from TWC staff as to how to report the work and earnings during her benefits week was not a model of clarity. And so granting a waiver of the overpayment can be supported under the facts of this case. Accordingly, we should modify the AT decision. The earnings adjustments were proper. The earnings adjustments created an overpayment, and the waiver of the overpayment should be granted.
I concur with Commissioner Demerson.
One moment, please.
Ms. Miller.
Repeat the case number again. Make sure we're on the same page here. Right. Okay. Let me consult real quick. Okay. asked to resubmit on the waiver issue.
Yes, sir. So we no longer have a majority vote?
Right.
Do you still wish to agree with Commissioner Dimerson?
We have a vote to rehear here. I'd like it if I turn my microphone on.
Actually, yes, sir, you're right.
We have a rehear here and a resubmit here. Tell me the functional difference between the two.
Resubmit would not involve a new hearing, just a new analysis.
Rehear.
We will rehear the case.
Case number 3390099, Commissioner Trevino.
This case should be reheard because the record was not well developed. The record is unclear as to whether the payments were made because the claimant working as a result of a collective bargaining agreement or the result of the employer supplemental unemployment insurance program. Further, the record is unclear as to whether the earnings adjustment in this case are regarding the same payments that were considered as non-disqualifying remuneration in the previous determination dated December 1st of 2020, February 11th of 2021, March 23rd of 2021, and the AT decision in case number 2972390. The case should be reheard to adequately develop the record as to any hours the claimant worked during the benefit weeks and the nature of the payments made. Rehear.
It's similar to the same, this is similar to the prior case. And so I'm going to read into the record and then we'll probably go resubmitting, but the AT decision is partially supportable. As with the companion case, the evidence establishes that the claimant did not report her earnings correctly according to commission rules. The earnings adjustments were based on the data reported by the employer and were appropriate. Earnings adjustment created an overpayment of benefits, which the decision correctly recognizes. Concerning a waiver of the overpayment, the claimant had a complicated situation involving an employer's program to pay employee a portion of their usual wages as part of an agreement not to lay them off. The program requirements during the pandemic were complex and led to many questions reaching TWC. For clear answers on claim-related questions was difficult during the pandemic, and the claimant gave credible testimony that the advice she received from TWC staff as to how to report the work and earnings during the benefits week was not a model, again, of clarity. And so granting a waiver of the overpayment can be supported under the facts of this case. Accordingly, we should modify the AT decision. The earnings adjustment were proper. The earnings adjustments created an overpayment and the waiver of the overpayment should be granted.
Rehear.
We will rehear this case as well.
Case number 3404829, Commissioner Dimerson.
The appeal tribunal decision should be affirmed. The claimant testified that she requested on-demand status with the named employer. The claimant also stated in a fact-finding statement that she asked the employer to reduce her hours. Since the claimant's reduction of hours was due to her own request, the claimant is responsible for any subsequent periods of unemployment. As such, the claimant quit without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, overpayment.
The AT decision is not supportable. The claimant filed a valid claim. She was partially unemployed when she filed her continued claim for benefits week ending of 9/17 of 2022 because she earned less than 125% of her weekly benefit amount during the benefit week. The claimant was working on an as-needed basis and was separated from the employer at the end of her last assignment. Additionally, there is no evidence that the claimant knew that at the time her assignment ended, when she would be scheduled for additional work. Though the claimant switched from part-time to on-demand on February of 2022, this occurred prior to the claimant establishing her benefit year against another employee with the effective date of 8/21 of 22. And this change in the claimant's employment status cannot be considered as a reason for the separation that occurred 8 months later. The employer failed to submit credible evidence that she turned down additional work. Therefore, the claimant was separated for reasons other than misconduct connected with the work. Reverse the AT, valid continued claim, no misconduct, no overpayment.
Voluntary leaving, overpayment.
Short form dissent, ma'am.
Yes, sir.
Case number 3420262, Commissioner Dimerson.
Although the employer missed a rehearing concerning timeliness of protest and chargeback, the record will not support a decision at this point. Current commission records are in conflict over whether the rehearing notice was actually sent to the employer. The computer records in the mainframe system indicate that no such notice was sent. While the record contains mention of a report based on unspecified facts that a rehearing notice may have been sent, the fact that the commission records are not consistent on that point shows that there is not any clear proof of the notice having been sent to the employer. The case should be reheard, and this time, clear evidence of the rehearing notice having been mailed to the employer's correct address record should be maintained. Accordingly, we should hold another rehearing and ensure that all of our records clearly and consistently show that the rehearing notice was sent to the employer as the law and due process require.
The AT decision is correct. The employer's response was late to the notice of maximum potential chargeback dated May 8th of 2020. The employer alleged that they had evidence of a timely filing, and a rehearing was scheduled to allow the employer to present that evidence, but the employer failed to appear for that rehearing. The employer has made no allegation that their response was late due to information from the commission indicating their account would not be charged due to COVID. There is no good cause exception to the timeliness rule. Affirm the AT, late response to the notice of maximum potential chargeback. Employer's account remains charged.
Timely response to the NMPC resubmit.
Agree with the chairman.
Yes, sir. We will resubmit the case.
Case number 3423452, Commissioner Dimerson.
The appeal tribunal decision should be modified. At her own request, the claimant's hours were reduced. Since the claimant initiated the request to have her hours reduced, any subsequent periods of unemployment are the claimant's to bear. We should therefore modify the AT decision, voluntary leaving, no chargeback, sever the adequate response issue. In the alternative, since the claimant's request that her hours be reduced was due to a medical issue, I could also support a vote to qualify the claimant for benefits and to protect the employer's account under medical separation analysis. Accordingly, we should modify the AT decision, no voluntary leaving, no chargeback, MVI, void adequate employer response.
The AT decision is not supportable. The claimant reduced her hours due to her medically verifiable illness following a medical leave. She worked consistent part-time hours for more than a year prior to filing her claim, though she had again requested part-time hours in August of 2022. There, her regular part-time hours were significantly reduced by the employer, leading her to file a claim for benefits. The employer did not provide a reason for the reduction in the claimant's hours, but merely testified that part-time hours are not guaranteed. Therefore, the claimant was constructively separated from her part-time employment for reasons other than misconduct connected with the work when her hours were reduced by the employer due to the business need. Reverse the AT, no misconduct, chargeback, void adequate response. However, as a claimant initially had reduced her hours due to her medically verifiable illness, and the employer testified that part-time hours are not guaranteed, I could agree that the finding that the claimant's reduction in hours and constructive discharge was caused by her medically verifiable illness. Modify the AT, no misconduct, no chargeback, MVI, void adequate response.
No misconduct, no chargeback, MVI, void adequate response.
Agree with the chairman. Yeah, it's fine.
Unanimous decision.
Thank you.
Case number 3442968, Commissioner Trevino.
The AT decision is incorrect. The co-worker of the claimant started yelling profanity directed at the claimant. The claimant was not the aggressor in the verbal altercation and presented credible sworn firsthand testimony that the co-worker used profanity and called the claimant a derogatory name. In the appeal number 87-20103-10-111287, the commission held that when the claimant engaged in a justified verbal argument with another employee, which consisted of profanity, but with no threat of physical violence, is not considered misconduct. Here, the employer has failed to meet its burden that the claimant was discharged for misconduct and that the claimant's action did not rise to the level of misconduct. Reverse the appeal tribunal. No misconduct, chargeback.
The appeal tribunal decision should be modified. The claimant was involved in a verbal altercation with a coworker, which included profanity. The employer testified that it had a zero tolerance policy regarding profanity. As a result, the claimant and the coworker were terminated. Both employer witnesses stated that the claimant admitted to using profanity towards the coworker. Since this is an admission against interest, it should be given greater weight than the claimant's denial. Therefore, the claimant mismanaged her position of employment and was discharged due to work-connected misconduct. Accordingly, we should modify the AT decision, misconduct, no chargeback, adequate employer response.
No misconduct, chargeback.
Short form dissent.
Yes, sir.
Thank you.
Case number 3521156, Commissioner Dimerson.
We should affirm the appeal tribunal decision. Although the employer required its employees to act in a professional manner, the claimant was terminated when she became argumentative and insubordinate during a counseling session. Since the claimant was warned about prior instances of unprofessional conduct, and because the claimant's improper behavior was corroborated by multiple witnesses at the employer's place of business, the claimant's action were mismanagement of her position of employment and misconduct connected with the work. As such, we should affirm the AT decision. Misconduct, no chargeback.
The AT decision is not supportable. The claimant was discharged due to alleged inappropriate conduct when response to a reprimand. However, the employer provided no specific evidence regarding how the claimant demonstrated the alleged aggressive and defensive behavior. The claimant testified that she merely responded to the reprimand in a professional manner and that any gestures that she used were part of her normal conversation style. The employer's generalized allegations were insufficient to establish that the claimant engaged in actions that could be considered misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
No misconduct, chargeback.
Short form dissent.
Yes, sir.
Thank you.
Case number 3521344, Commissioner Dimerson.
The appeal tribunal decision should be reversed. While the consistency between the employer's testimony and its documents was not perfect, the evidence in this case still establishes that the claimant neglected his job duties, which was mismanagement of his position of employment. Should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision is supportable. The claimant stated that he was not on call on his last day. He was late to his job because the company vehicle broke down and he had to get a new truck from the employer's work site. He also denied performing work on the other side, on the side, and denied that he had a passenger in his work truck. The employer has the burden of proving misconduct. Their witnesses' vague hearsay testimony conflicted with the employer's prior statement to the commission regarding the reason for the separation and was insufficient to prove that the claimant was discharged for misconduct. Affirm the AT, no misconduct, chargeback.
Rehear to obtain firsthand testimony and clarify the employer's evidence.
I agree with the chairman.
We will rehear the case.
Thank you.
Case number 3526472, Commissioner Trevino.
The AT decision is not supportable. The claimant provided credible firsthand testimony that she did not engage in any insubordinate behavior. After the claimant expressed her concerns about being overwhelmed and unable to provide proper patient care without additional help, the claimant clocked out for the day to pick up her sick, ill son from the doctor and to care for him. The claimant's firsthand testimony carries greater evidentiary weight than the employer's secondhand hearsay testimony, and the claimant's actions should not be considered misconduct connected with the work. Reverse the appeal tribunal, no misconduct, charge back, sever adequate response.
We should modify the appeal tribunal decision. Testimony from the Assistant Director of Nursing and additional written statements established that the claimant yelled at multiple staff members in front of residents. The employer's attempts to diffuse the situation were unsuccessful, and the claimant ultimately walked out on her shift. Because the claimant was disruptive, insubordinate, and refused to follow instructions in violation of the employer's policy, she mismanaged her position of employment. We should modify the AT decision, misconduct, no chargeback, adequate employer response.
Misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir. Thank you.
Case number 3542255, Commissioner Trevino.
The AT decision is not correct. The claimant was terminated due to the employer's dissatisfaction with her job performance. The employer failed to establish that the claimant was ever able to meet the employer's expectation for her assigned job tasks. The claimant performed her job to the best of her ability, and her inability to perform the work to the employer's satisfaction does not rise to the level of misconduct. Reverse the AT, no misconduct, chargeback.
We should affirm the appeal tribunal decision. Although the claimant alleged increased workload and increased scrutiny of her work as the basis for her separation, the records show that the claimant's work was not examined at a higher level compared to other employees. In addition, since the claimant was provided adequate opportunities to improve, and because the claimant's fact-finding statement suggests that her decline in performance arose from personal circumstances unrelated to work, the claimant mismanaged her position of employment. As such, we should affirm the AT decision, misconduct, no chargeback.
Misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir. Thank you. And that was the last unemployment insurance case pulled for additional discussion on docket 44. You should have received the UI short form dissent list for docket 44.
I move we accept staff recommendations on the remaining UI cases on docket 44.
And I second the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 44.
And I concur with Chairman's motion, except for those cases on which I am dissenting as reflected on UI short form dissent list for docket 44.
Motion passes with the exceptions noted.
Thank you.
Thank you. We'll take a short recess.
Chairman, before we recess, can I come back
Sure.
in?
Commissioner Demers.
Yeah, my last docket hearing here today, and I wanted to express my appreciation to Sherry and her team for all you guys have done. Eric back there, Lachey, Melissa, the work that you guys have done. We appreciate it. You made it easy to the point of when we're sitting here and looking at what you guys are doing. It's a lot of work, and we appreciate that all through the pandemic as well. And want you guys to make sure that the team knows that quite often when we're looking at cases, we have done this. I think our former commissioner, Alvarez, and I've done it, been guilty of it. Commissioner Trevino hadn't done it yet, but you end up reading the wrong case sometimes. And so that can be quite alarming. And I love how you guys get us back on track with that. And you made it this process very easy. So thank you for all you guys done. The professionalism is superb, and we don't take what you do for granted. So I wanted to share that, and thank you for working with our team as well. They have a great working relationship, and we get work done in that regard. And I wanted to say thanks for all of that.
Thank you, Commissioner.
You're welcome.
Congratulations on your new opportunity, and it's been our pleasure to serve you.
Thank you. Thank you. That's it, Mr. Chairman.
Thank you. We'll take a short recess. All right, this is agenda item 9, memorandum of understanding between Texas Workforce Commission and the Texas Higher Education Coordinating Board.
Good morning, Chairman, Commissioners, Mr. Cerna, Courtney Arbor, Workforce Division. I'm seeking your approval today to execute a memorandum of understanding with the Texas Higher Education Coordinating Board, which will be signed today by Mr. Cerna, assuming it is approved today. This agreement formalizes the key projects and strategies that we are working together on with the coordinating board, both now and in the near future. The strategies include talent pipeline, credential library, opportunity high school diploma, work-based learning, coordination of employer engagement, and coordination of grant activity. I'm happy to answer any questions that
Comments
you
or
might have.
questions?
None here.
None here.
Is there a motion?
Chairman, I move that we approve proceeding forward with the proposed memorandum of understanding between the Texas Workforce Commission and the Texas Higher Education Coordinating Board to jointly implement certain workforce development strategies as recommended today by staff.
I second the motion.
Vote unanimous, motion passes.
Thank you.
Agenda item 10, final rules on chapter 838, Texas Industry Recognized Apprenticeship Program, Grant Program.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Trevino, and Mr. Sarna. For the record,
Yes, you said I'm on this.
my apologies for that. I'm going to start over. Good morning, Chairman Daniel, Commissioner Demerson.
Aaron Demerson.
I guess this is me acting out, this being your last day, right?
Gary. Grief is a normal response when somebody's leaving. Don't be embarrassed by it. Like we all go through a series of emotions. I will point out for the record that you did account for Commissioner Trevino. It was Commissioner Demerson. In other words, you're preparing for his exit, and that's
I am.
okay.
It is the only way I can do this.
I understand.
Okay.
Do you want to walk back and sit down and then try it again, or are you just going to start from there?
I better not.
Okay.
I better
I,
not.
I was oblivious to it all.
Oh, for the record, Carrie Ballast, Workforce Development Division. Commissioners, before you today for your consideration and adoption are final rule amendments to Chapter 838. In an open meeting on August 22nd, 2023, the Commission approved proposed amendments to TWC's Chapter 838 rules regarding the Texas Industry Recognized Apprenticeship Program. The proposed rule amendments were published in the September 1, 2023 issue of the Texas Register for a 30-day public comment period. Public comments were received. Staff reviewed and responded to the comments, but no changes were made to the proposed rules. Staff recommends adopting the amendments to Chapter 838. Should the commission adopt these rules, staff requests the ability to make minor non-substantive changes to the document in order to comply with publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my remarks. I'm available to answer any questions that you may have.
Comments
Thank
or
you.
questions?
None here.
I would like to thank everyone who submitted comments during the public comment period. The amount of public involvement shows how important and needed the Texas Industry Recognized Apprenticeship Program is. I look forward to seeing this implemented and the many Texans who will benefit from these training programs. Thank you.
Awesome. No comments.
Is there a motion?
Mr. Chairman, I move that we approve the adoption of amendments to 40 Texas Administrative Code, Chapter 838, Texas Industry Recognized Apprenticeship Grant Program is recommended today by staff.
I second the motion.
Vote unanimous and the motion carries. All right, agenda item 11, pre-apprenticeship training program funding for fiscal year 2024.
Good morning, Commissioners. For the record, Carrie Ballast, Workforce Development Division. For your consideration today is the fiscal year 2024 planning estimate for pre-apprenticeship training programs. Each year, the Texas Workforce Investment Council makes recommendations regarding Chapter 133 apprenticeship training programs. This year also, TWC recommends for the FY24 pre-apprenticeship program a maximum pre-apprenticeship cost per participant of $2,000. Commission decision points for the FY24 funding are as follows. A planning estimate of $1,815,527 in general revenue for FY24 pre-apprenticeship funds, and an FY24 maximum pre-apprenticeship cost per participant of $2,000. As required by TAC Rule 837.21, with the Commission's approval, we will provide public notice of the amount of funds available to support pre-apprenticeship training programs for FY24. This concludes my remarks. I'm happy to answer any questions.
Questions or comments?
None here.
The pre-apprenticeship program are a great way to prepare individuals with additional training and instruction before going to a registered apprenticeship programs. I'm happy to support this, and I would like to request that you brief us at the end of fiscal year 24 on the success of the program to see if additional funding is needed based on that demand. Thank you.
Is there a motion?
Chairman, I move that we approve a planning estimate of $1,815,527 in general revenue for fiscal year 2024 pre-apprenticeship funds and a maximum pre-apprenticeship cost per participant of $2,000 is recommended today by staff.
I second the motion.
Vote unanimous, motion carries. This is agenda item 12, purchasing from people with disabilities program, Central Nonprofit Agency, fiscal year 24 management fee.
Good morning, Commissioners. Mr. Serna, Juan Garcia with the Voc Rehab Division. This morning for your consideration and approval are the proposed central nonprofit agency management fee rates for FY24, along with the method of calculation. Section 806.31 of the Texas Administrative Code requires the Commission to approve the management fee rates and the method of calculation on a yearly basis. The proposed rates and the method of calculation is presented in the discussion paper before you remain unchanged from last year. The rates are 6% for products and services and 5% for temp services. As required, the rates were posted for a 60-day public comment period. 2 comments were received, both were positive and supportive of the proposed rates. Staff recommends the approval of the management fee rates and the method of calculation is presented in the discussion paper. With that, I can answer any questions you might have.
Comments or questions?
None here.
None here.
Is there a motion?
Mr. Chairman, I move that we approve the purchasing from people with disabilities program fiscal year 2024 central nonprofit agency management fee rates and method of calculation as described in the discussion paper and recommended today by staff.
I second the motion.
Motion carries. So agenda item 13, reemployment services and eligibility assessment pilot funding.
Morning, Chairman, Commissioners, Mr. Serna. For the record, my name is Dawn Cronin with the Workforce Division. Before you today in your briefing materials is the RESEA subsequent meeting pilot for consideration and funding. The pilot is to fund subsequent meetings for RESEA claimants. The staff is recommending the use of RESEA grant carry forward funds to support the 12 boards participating in the pilot. Distribution to these 12 boards is based on their current RESEA performance, their expenditure patterns, historic outreach pools and workloads. Staff is recommending to use a total of $2,065,000 in carryover funds to distribute to the boards participating in the pilot. And staff seeks direction this morning on the use of these RESEA carry forward funds to distribute to the 12 boards participating in the subsequent meeting pilot. And I'm happy to answer any questions.
Comments or questions?
None here.
None here.
Is there a motion?
I move that we approve the use of carryover funds distributed to the 12 local workforce development boards participating in the reemployment services and eligibility assessment subsequent meetings pilot as described in the discussion paper and recommended today by staff.
I second the motion.
Motion carries. This is agenda item 14, board nomination.
Morning, Chairman, Commissioners, and Mr. Cerna. For the record, Cherie Dudley with Workforce Development. Today, for your consideration, we have Workforce Board nominations for Concho Valley, North Central Texas, Golden Crescent, North Texas, Northeast Texas, Coastal Bend, and Rural Capital Area. Staff recommends approval on the presented nominees, and I'm here to answer any questions you may have.
Comments or questions?
None here.
None here.
This list is exceptionally long. Did you do this in honor of Commissioner Demerson's last commission meeting?
Sure, yes.
You did?
Uh-huh.
Well done. Good work.
Okay,
Is
thank
there a
you.
motion?
Mr. Chairman, I move that we approve the local workforce development board member nominees presented today for the following workforce solution areas: Workforce Solutions Concho Valley, North Central Texas, Golden Crescent, North Texas, Northeast Texas, Coastal Bend, and Rural Capital Area.
I second the motion.
It's been moved and seconded. Vote unanimous and the motion carries.
Thank you.
Thank you. Well, we're to the part of the program where we ask for any other order of business from the commission. Before I let Commissioner Demerson talk, I would just say, this is in fact your last commission meeting. What a pleasure it's been to serve with you. Although we've been friends, I was trying to figure this out the other night. I think it's 25 years at this point.
It's a long time.
It's been more than 2 decades, and it's been a pleasure to work with you, but I don't think that's really going to stop. We work a lot with the Texas Economic Development Corporation, and I know that we'll continue to do that. And it's good to have a friend there working there. Looking forward to continuing our work in economic development, which is now nearly 3 decades old, and I think we've still got a lot of work to do, and I'm excited to really do that.
Yeah, and I agree. I mean, we've been working together just a short time, but in talking to Commissioner Alvarez and the friendship that you all had, and just the mentorship that you gave me while I was here, just barely starting out, and the confidence and professionalism that you showed inspires me to continue that. So I look forward to you doing bigger and better things in the future and working with us as well. And just appreciate everything that you've done in my short time here, and everything that you've explained and given to me that you could. So appreciate that.
Good. Mr. Cerna, you have a few things you want to get off your chest. So 11:24, so.
I will comment that I noticed all the staff after Carrie simply said either Mr. Chairman, Commissioners, or Commissioners. None of them try to name y'all anymore.
Carrie's a leader.
Yeah. I do want to, for myself and also for all the staff at TWC, congratulate Commissioner Demerson, and also express our appreciation for all the support that he's given the staff as a commissioner, and then also for his successes as a member of the staff, which is kind of unique as a member of the staff for so many years. I've known Aaron for some time as well. That happens when you get old, you just end up knowing people for a long time. But he's done an outstanding job. We wish him well in his future endeavors, and we'll continue to work with him however we can to continue to advance Texas. So with that, Commissioner, good luck.
Good, thank you, Ed. And so I'm gonna have some comments, but let me do this part of business first, and then I'll get to the other. I heard more information. Shared a little bit about career exploration and providing mobile career exploration labs could be a solution. I hope that in the immediate future, the commissioners would work with local partners to provide an opportunity for more enhanced career exploration and training simulations. I think Commissioner Trevino, you've had an opportunity to kind of look at some of those mobile units and the like, and with the short time frame that I have here, I'm not able to push that initiative through, but I hope the commission would take a hard look at that down the line. We have employers that are jumping in a big way in supporting those efforts, and so hopefully we'll see some work and some results down the line there. Mr. Chairman, you're exactly correct. We've known each other for a number of years, a long time. I was trying to think the same thing, and it's been a good journey over the years, and to come full circle here at the commission has been a joy working with you, Commissioner Trevino. The short amount of time that we've had has been meaningful and impactful. I mean, we've had a good opportunity, and you're doing a good job with the team that you have, and I wish you well in the future, and I know that that's going to continue moving on. I think I have a celebration or something from 11 to 1 today that the team's kind of putting together as well, but our relationship and friendship goes way back as well. I think you had the relationship with my wife before me, and so Rose is in the audience and the like, and so but appreciate the friendship, the way that God just kind of lined all of this up to come here full circle and to end up where I am now, and a tremendous team that's out here. And I said that I'll say this in some of the comments when we finish, but in my resignation letter to the governor, I was just applauding the team on what we've done before, but during the pandemic has been just truly phenomenal. And I think we're gonna all kind of look back at that at some point in our lives and realize the work that was put into that. But I've had a fantastic run, and it's only done with the support of the team. And I truly continue to appreciate that, Ed's leadership, working with my fellow commissioners, chairman, you've been in that position for quite some time and leading us through the pandemic and the like. It's not for the faint-hearted, and so we appreciate it and don't take any of that for granted. And then to my team, a dynamic team on the, started with the OEI team, but now the team that I have in the commissioner office is just a solid group of people, and I'll tell them that over and over. And so before I close out, I wanted to, oh, and one other thing, April Fools, I can even tell you guys now, I'll still get you from afar. And so I see Julia over there shaking her head, but we'll continue that even from afar, but it's been a pleasure. And so Josh, if you can help me with the bag, bring that bag up here real quick. That's our intern, Josh. And so his last duty today, he has no idea what he's doing. The other bag as well, Josh, you left one right there. And then Leif, you can help me with the whatever you brought in. So stop at Ed's desk real quick, Josh, with that small bag, giving him good instructions. Not that one, the other one. There you go. Ed, you can pull that out. So Ed, I would always have an apple on my desk, and I can always tell that Ed has been to my office because of the apple. And Ed and I have this relationship about apples. And so Ed, that's Honeycrisp and Fuji apples there. And so down to that part. And so just appreciate his relationship, and then give this is an Alamo draft card for Ed and Alex. How old is Alex now? 11. And so I probably met him when he was 2 or something. I used to lift that young man up or so. And so I gave Ed a Christmas gift for him and Alex to go watch a movie. And so this is an opportunity to go watch another movie as well. Thank you, Ed, for all your work. Let's give Ed a round of applause. Appreciate you. Secondly, let me see what we have over here. Our chairman is a man that knows a lot about everything, a lot about everything. I've heard him talking about all kinds of issues. And so I got the chairman of the Texas Rangers, the official commemorative bicentennial guide, all about the Texas Rangers. I know he's going to enjoy reading that. Also, the National Geographic Titanic, Exploring the Discovery of a Lifetime. And so this is good book there. Texas Highways, a higher plane, explore the one-of-a-kind culture at the top of nowhere. And that's his Amarillo right here. But this Texas Highways book, I know the chairman would appreciate that as well. His videos have gone all the rave. And so Entertainment, The Ultimate Guide to Yellowstone. I've not watched that yet, but I was trying to find something with Hollywood there, but I couldn't find anything. So the closest that I got there. Always tease, if the chairman gets one bite on those videos, he's leaving you guys. He's gone to higher and better things. And then this is the ultimate, the Taylor Swift fan book. She's getting everything.
You were doing so good.
The incredible story of her rise from country singer to global icon. This is the last one to the chairman, so. No, no, sorry. Blake, you got a coffee cup? No, you need a coffee cup. And I have a Starbucks card for you, Chairman, to drink coffee with those,
Well,
with
read
those
my
mags.
books,
That's
yeah.
right, so. And then that one. Okay. And lastly, to Commissioner Trevino, join the club. That's a Texas umbrella that all the commissioners have been graced with. And so you think about me whenever you pull it out and you keep that in your car when it rains, whatever, you're gonna say, God, that was a good thing that Commissioner Demerson did. And appreciate that big time.
The 4 times a year that happens, I
That's
think
what
that
you got.
every single time.
But you use it in the sun and people love you because it covers a lot of space. And so that's a good umbrella and everybody will know you because it's a Texas size and a Texas emblem umbrella. But again, I appreciate all of you guys and what you've done to make my life easier as I go to the Texas Economic Development Corporation, an awesome opportunity. And the governor just has he's ready to do some amazing things. And so we can only do that together. And so I'm looking forward to bringing you guys into that fold right away. And Chairman, you mentioned it, we're going to be able to do some amazing things with workforce and economic development, coupled with education. All of those things are phenomenal. And this agency has a lot that can be shared. And I'm going to be doing that, sharing the best workforce team in the nation, in my opinion. And so thank you guys for everything. This is my last commission meeting, but I think we have some other celebration taking place. But it's been a joy, a delight. Love you guys all. And if I can do anything in the position that I have over there, I'm always willing to help any individuals, both professionally and personally. And on a personal note, even to the point of helping Courtney this morning, other duties as assigned. I'm walking into the building and Courtney is trying to get into the garage, but she's parked. Here's the key fob here, but Courtney's parked about right here. And all I see is somebody just dangling their card out like that. So I came up to help her out. So Courtney, thank you for that last additional duty as well. So thank you guys for the opportunity and the time.
Thank you.
In 4 years, Aaron Demerson has only ever complained about one thing
What was that?
relative to being on the commission. And so today, as a final act of service, I will relieve you of the only burden you've ever complained about. Commissioner Trevino, I move to adjourn.
I second that.
Oh, okay.
We are adjourned.
I'm totally confused.